Who's next?
Members of the panel, before I begin, could I first check that everybody can see me clearly and hear me clearly?
Yes, very much so.
Thank you,
Let's
Mr.
go.
President. Good afternoon, members of the panel. My name is Seah, and I'll be speaking on behalf of the Respondent, the Games Disciplinary Committee, henceforth the GDC, on the first issue regarding the GDC's quorum and a fourth issue on doping, which are Mr. Lander's issues on appeal for 14 minutes. My co-counsel, Mr. Brendan Zhang, will be speaking on issue 2 on the location of the tribunal and issue 3 on Ms. Tang's ability to participate in the qualifying games, addressing Ms. Tang's issues on appeal for 15 minutes. We respectfully reserve 1 minute for a rebuttal. Members of the panel, this case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules and integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and ensure that games are conducted equally without illegality or undue advantage. With that, I make two submissions addressing Mr. Lander's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent arbitrators. Secondly, the GDC did not err in finding that Mr. Lander had been liable for doping. Bluebet, in its nature, is a performance-enhancing drug. Turning to issue 1, if I could first turn the panel's attention to para 37 of the record. What Mr. Lander intends to do is to challenge an arbitrator. To determine if an arbitrator should be challenged, the applicable rule should be Rule 34 of the CAS Code. Rule 34 states, and I quote, "An arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or impartiality." This threshold of legitimate doubt is similarly noted in Article 180 Part 1c of the Swedish Federal Act on Private International Law, which states, and I quote, "An arbitrator may be challenged if circumstances that give rise to justifiable doubts as to his independence are present." And most crucially, the threshold of justifiable doubt can be found in the exact wording featured in the Malaysian Arbitration Act at Section 14.3 Part A, which states, and I quote, "An arbitrator may be challenged only if the circumstances give rise to justifiable doubts as to the arbitrator's impartiality or independence." This demonstrates that the evidence of biasness must be justifiable and concrete, and this threshold has been applied stringently to related cases. I note that counsel for the appellant has raised the case of Sanyang and World Anti-Doping Agency, and in that case, we do agree that they did address the issues of an objective bias. However, they caveated that importantly, there must be concrete facts objectively giving rise to a lack of independence. If I could then turn the panel's attention to para 4 of the record. If the panel is with me, Ms. Farina is merely described as Ms. Tang's cousin sister. While this indicates a blood relation, it's a relatively distant one, and there's no evidence in the record that suggests any meaningful or personal emotional closeness between them. The absence of any indication of frequent interaction, shared household, or personal involvement beyond this genealogical link supports the inference that their relationship is more nominal rather than substantive. Moreover, although the record in para 4 mentions that Ms. Farina had provided some on-the-side coaching, this should be viewed as a limited and informal engagement. There is no suggestion that she held a permanent coaching position or received remuneration.
In fact, can I just stop you there?
Certainly.
You said that Miss Farina gave some ad hoc site coaching. Is it? But what I'm reading here was asked to guide. That's what I read. So I'm not even sure whether she did it.
Actually,
Isn't it?
certainly, Mr. President. In fact, that fact actually goes in favor of our case. we do not even know whether coaching actually did take place in the first place, and we have actually considered that coaching did. So if coaching didn't even take place in the first place, then there wouldn't even be a professional relationship in the present case. And with regards to Mr. Douglas, the professional interactions such as the fan meetups as seen from para 26 of the record, where both Mr. Douglas and Ms. Tangs were spotted together, are typical of public figures in the esports realm and do not indicate a privileged or adversarial relationship that will compromise his judicial capacity. The one-time special and personal sharing session, which the appellant has sought to rely on, was the events that took place crucially 6 months prior to the tournament, as seen from para 26 of the record. A single historical event does not establish an ongoing dependent relationship that will necessarily sway his judgment regarding the complex legal issues of doping and eligibility. Crucially, even if there was a finding of a relationship, there must be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence or impartiality. This is noted in the 2015 case of ABB heard in the Federal Supreme Court of Switzerland. At para 2.2.1, they emphasize that impartiality and a lack of independence is only found if there are ongoing economic ties or ties that have ended recently. And in our case, there's clearly no economic ties between Ms. Farina and Ms. Tangs, as they are merely distant family members, in which Ms. Farina had only asked, Ms. Tangs had only asked Ms. Farina to be a coach, as rightfully pointed out by Mr. President. Noting that Mr. Lander is the one alleging the presence of a lack of independence, the burden of proof will be on them to prove so. And with respect to Mr. Douglas, there's only a coaching relationship as well, as seen from para 26 of the record. While their relationship did get closer, there's still no evidence of any economic ties of which Mr. Douglas would have had profited in ruling in favor of Ms. Tangs. And lastly, I note that the appellant has raised the issue of non-disclosure. However, this is not fatal to our case. In the 2021 case of AN International Federal Association Football, the challenge arbitrator, Mr. Mark Horvel, had regularly failed to disclose information relating to past cases. And it was noted that while his practice of such non-disclosure was found inappropriate and contrary to the requirements linked to the duty of disclosure, nothing indicated that this practice was a deliberate intent by the arbitrator to conceal his information, and this is presently what is happening in our case. There's no deliberate attempt either by Mr. Douglas or Ms. Farina to conceal their prior relationships with the court. Crucially, Ms. Farina's reason for the lack of disclosure was that she had figured it was public, as seen from para 27 of the record, which suggests an absence of intent to hide the association based on a belief that the information was already known. Furthermore, at para 27 of the facts, Ms. Farina had assumed her relationship with Ms. Tangs was considered to be public information. And such, and similarly to Mr. Douglas, he was previously an online streamer and gamer and has been seen on occasions with Ms. Tangs in fan meetups. Given that the initial connections between Mr. Douglas and Ms. Tangs showed, including his role as a gamer and appearance as fan meetups, was already in a public domain, i.e. it was known by everybody else, the notion that either party maliciously tried to conceal their relationship is undermined. Conclusively, both Mr. Douglas and Ms. Farina are biased members of the tribunal. Unless I may be of further assistance on the first issue.
Carry on.
Thank you, Mr. President. I'll turn to the fourth issue on doping. We have two main submissions. Firstly, the GDC acted within its jurisdiction in finding that Mr. Lander committed a doping violation under Rule 12 of the qualifying game rules. And secondly, the GDC's decision was consistent with CARE's jurisprudence and Lex Portavia principles. As noted in Rule 12 of the qualifying games, Rule 12 defines a prohibited substance as, and I quote, any substance or method contrary to the spirit of the sport. And I note that Mr. President had queried the appellant previously on what is the meaning of spirit of the sport. And this is the area that I would like to assist Mr. President in understanding. As provided in the WADA Code at page 13, the spirit of the sport is a celebration of the human spirit, body, and mind. It is the essence of Olympism, and is reflected in the values we find through sport through the value of excellence in performance. And excellence in performance is precisely what is being contended here. Putting this in context of Quidog, it is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Lendert knows very well, with himself coming in clutch in draw-breaking games as seen at para 6 of the record. If I could then turn the panel's attention to para 12 of the record, in the final match between Mr. Lendert and Ms. Tangs, their close draw-breaking game is noted to be extremely tired on the eyes and mind. Therefore, the player who deserves to win is the one who is able to, without any doping or assistance, focus all the way to the end. However, Mr. Lendert was only able to win with the assistance of Bluebat. Crucially, if I could turn the tribunal's attention to the very same paragraph, Mr. Lendert, knowing that Bluebat could keep his energy up, kept the drink nearby. Ms. Tangs, with a dominant performance, as seen from para 11 of the record, was bound to have won the tournament, if not for Mr. Lendert's intervention of 5 points. This concentration-enhancing drug essentially allowed Mr. Lendert to take the edge over Ms. Tangs as seen at para 13 of the facts. Therefore, his actions go against the core of rewarding a player's excellence in performance, which is against the spirit of the sport and noted by Mr. President earlier. Furthermore, Rule 13 of the qualifying game rules instructs that athletes are to refer to the WADA prohibited list, but the term refers signifies guidance rather than exclusion. Nowhere in the qualifying game rules actually exclude that Rule 12 should not be read. In fact, it is clearly written there for the athletes to conform to, and the meaning of spirit of the sport is clearly provided in the WADA code. Therefore, the Commission's reliance on Rule 12 was appropriate, and the GDC's decision to find Mr. Lendert liable for doping is consistent. Secondly, the GDC's decision was also consistent with CAS jurisprudence and Lex Sportivia principles. In the 2004 CAS case of Maria Louis Kelly Williams and IOC, the tribunal accepted that an unlisted substance could still fall within the scope of the code if it exhibited similar pharmacological effects or violated the spirit of the sport. Professor Caitlin's medic expert report, cited at para 3 of the judgment, concluded that although not expressly listed, isomethapine, the substance in that case, had a similar pharmacological effect to other prohibited substances under the IOC rules. The panel accepted that anti-doping authorities could act on such evidence to preserve fairness, and analogously, Bluebat enhanced concentration and alertness in competition, mirroring the very harms that anti-doping rules are meant to prevent. And crucially, this is further upheld in the 2005 US case of US and Conte, where the arbitrator held, and I will quote because it's important, it will be impracticable to identify all forms of steroids in a list of prohibited substances, and restricting the prohibition to certain named substances will be both unfair and detrimental to sport. And this reasoning directly supports the GDC's proactive stance by developing Rule 12 to function as a catch-all clause. I know my time, members of the panel, and this concludes my submissions on the first and fourth issue, and we pray that the panel undoes the ruling made by the GDC to find that Mr. Lendert instead was not liable, that Mr. Lendert was instead liable for doping. Unless I may be of further assistance to the panel.
Hello, thank you very much for your submission.
Thank you, Mr. President. The remaining arbitrators, if there's any issues. Thank you, members of the panel. I'll now hand over my time to Mr. Brandon Zhang, who will address the remaining 2 issues on appeal. Thank you.
Hello. Could I just double check that the panel can see and hear me?
Yes, we can confirm that, yes.
Good afternoon, honorary members of the panel, Mr. President. My name is Brandon Zhang, appearing for the Respondent, the game's disciplinary commission. I'll be speaking for 15 minutes. We submit that the GDC did not err in allowing the tribunal to be set up in South Nankaland, and that the GDC did not err in deciding that Ms. Tangs is ineligible to participate in the qualifying games. If I may direct the panel's attention to paragraph 25 of the record. A day after the tournament, there were massive riots against the government. The riots subsided after 3 days. Pursuant to Rule 23, Sub 2 of the qualifying game rules, the tribunal shall be set up within a week from the end of the tournament in the country where the tournament was held, where reasonably practicable to do so. In the present case, given the circumstances of the case, it was a matter of safety to leave the country. And clarification number 22 states that the massive riots took place in the city of Rambutana. And more importantly, it was not known how long at the time the riots would last, and also of equal importance, whether the protesters would start another riot within the same week, even after the 3 days. And at paragraph 29 of the record, the hearing was held in the Global Games headquarters in South Nankaland. And we submit that merely because it was at the Global Games headquarters does not mean that there was any impartiality or procedural unfairness. It was chosen because it was the most convenient place to hear the dispute and share information amongst the parties, because the parties include the qualifying games medical team, the games committee, and the International Video Games Federation. In addition, the country is an Oceania country, and Ms. Tangs was also born in an Oceania country and holds a citizenship of an Oceania country. And lastly, clarification number 16 states that when there is a disagreement about the location, that the GDC has the final say in the event that there is a disagreement. And clarification number 21 shows us that the parties were informed of the GDC location of the hearing. And therefore, at clarification 20, evidence had been formally submitted, and the court heard both parties' oral arguments and accepted their written submissions at paragraph 33 of the record. And therefore, we submit that there was no unfairness, there was no procedural unfairness, and Ms. Tangs was able to present her case. And accordingly, we pray that prayer B be dismissed and the GDC's decision be upheld. If there are no questions, I will turn to the second submission.
Please proceed.
Thank you, Mr. President. Turning to the second submission, we submit that the GDC correctly decided Ms. Tangs was ineligible to participate. The qualifying game rules under Rule 3, Sub-Rule 1 states a person is eligible to be a participating athlete if he or she is a citizen or permanent resident of a country in Asia. Members of the panel, CAS jurisprudence has held that the rules must be interpreted as to discern the true intention of the rule maker. In the 2013 case G&K Dynamo versus UEFA at paragraph 9.11, the court held that the rules must be applied according to their spirit, not merely according to their letter, and that the panel has to interpret the rules in question in keeping with the perceived intention of the rule maker and not in a way that frustrates it. As the appellants argue the rule, they allege that essentially their argument is flawed because the courts had frustrated the rule by reading additional rules into the Rule 3. In the present case, GDC correctly interpreted and applied this rule. And the intention and underlying purpose of the rule maker, the qualifying games, was simply for the games to be represented by Asian athletes who were citizens and permanent residents. And therefore, we submit that Rule 3 was interpreted correctly and discerns the true intention and purpose of the rule makers. Turning to the next point, we submit that Ms. Tangs had no genuine close connection with the country of Doriana and therefore is ineligible to participate in the qualifying games. As the appellant had previously stated, jurisprudence of CAS has held there is a distinction between legal citizenship and nationality. In the 1999 CAS advisory opinion of International Baseball Association at paragraph 27, the panel said a person may have 2 or more legal nationalities, but every athlete can only have 1 sporting nationality. And Mr. President and members of the tribunal, the sporting nationality essentially can be said to be the genuine alliance of an athlete to its country. And in the CAS 2000 case of Mr. Angel Perez versus IOC at paragraph 17 through 20, the tribunal cited the ICJ's Notenbaum case. And briefly to summarize, in that case, Mr. Notenbaum, while on a visit to Europe, obtained Liechtenstein nationality, a legal citizenship. And after the beginning of the Second World War, he returned in 1940, less than a year later, to Guatemala. And when Liechtenstein claimed compensation from the government of Guatemala on the ground that Guatemala had acted towards Mr. Notenbaum contrary to international law, the ICJ court held that Mr. Notenbaum's nationality was not based on any prior genuine link with Liechtenstein, and the sole object of his naturalization was to enable him to acquire the status of a neutral national in time of war. And what this shows us here, members of the panel, is that CAS jurisprudence recognized that formal citizenship may be disregarded for ineligibility purposes where the athlete has no effective connection to the country that they represent. At paragraph 20 of that case, the panel, I quote, "The notion may be indeed relevant in deciding to disregard formal nationality or citizenship." And in the present case, we submit Ms. Tangs does not have a genuine prior existence of a connection to Doriana, even though she holds citizenship. And we do acknowledge at paragraph 32 of the record that she had recently moved to Doriana, and therefore it is unlikely or improbable that she would be able to, in that short period of time, establish a genuine connection to the country. And furthermore, in the case of 2007 Melanie Rinaldi versus FINA, the court held that in order to be a real change, that the residence needs to correspond to the center of the athlete's activity in terms of everyday life, including training and competing for a sufficiently significant period of time to establish a real residence. And in the present case, there's nothing in the record on the facts to provide this sort of evidence, such as school records, employment records, and so forth. And lastly, members of the panel, this concludes my submissions. We submit that the GDC was therefore correct to demand that Ms. Tangs demonstrate more than a passport and that she had to show a genuine connection to her new country. And therefore, we pray that Prayer C be dismissed and the GDC's decision be upheld. Unless I may be of further assistance.
Yes, Jimmy, I have a couple of questions.
Yes.
You're saying that there's no genuine connection, Ms. Tang has no genuine connection to Duriana. I'm just looking at paragraph 3 of the facts. She has been known to be the local favorite in Asian tournaments, and that's because she's a rising star as a player and Duriana online streamer. And it says that while she is currently in Duriana, she was born in Chikustan, lived there for about 5 years, and then due to her father wanting to move back to his country, Duriana, she followed him and lived there for the next 9 years. So she spent 5 years in Chikustan and 9 years in Duriana, am I right? So that's how it looks like. So how does that not make her have a genuine prior existence or connection with Duriana? I just want to understand that. Help me understand this.
Yes, Mr. President. The jurisprudence is that, as cited by the Angel Perez case, is that the time spent in the country does not automatically mean that there is a genuine connection or a genuine alliance. In the Mr. Perez case, he spent 5 years in the US, and the court held that he did not have a US sport nationality. In the Melanie Rinaldi versus FINA case, at paragraph 11, the panel observed that it was undisputed that Ms. Rinaldi had resided with her grandmother, aunts, and other close relatives in Portugal for significant periods of her entire life. However, because she left the country and then returned to compete, the court held that the prior time spent could not be considered relevant to the requirement of sufficient time for the eligibility purposes, Mr. President.
Okay, so that's a negative, but what does then constitute sufficient time for eligibility then? What would the examples be?
The Melanie Rinaldi case says in order for a real change, there has to be a corresponding to the center of the athlete's activity, including training and competing, and also other cases of CAS jurisprudence mention employment records and school records as well, and employment contracts, Mr. President.
All right, okay. Thank you very much for your submission. Thank you.
Thank you, Madam Arbitrator. Is there a question?
Yes, may I ask question?
Yes.
Okay, you mentioned about a few cases that you precisely mentioned about the residency, but if you read also the qualifying games rules in athlete eligibility, it mentioned that a person is eligible to be participating athletes if he or she is a citizen or permanent resident of a country in Asia. So not only a citizen, but even a permanent resident is also allowed to participate or eligible. How you can, even permanent resident is allowed. So why even a citizen, even if she is a dual citizen, cannot participate. Thank you.
Thank you, Madam Arbitrator. I know my time is up. May I have the time to respond to your question?
Certainly.
If I may just clarify, the question is why allow participation if there is a PR requirement? Madam Arbitrator, this would be an issue going towards also the what is termed nation shopping, and this is where athletes switch alliances at the whim of a hat, so to speak, to gain personal advantages and fame. And for example, I believe at paragraph 3 of the record, she's a rising Doriana online streamer, and therefore she merely moved back to the country rather quickly to accept this offer for financial gains. And this also created unfair competition as the CAS courts has recognized. For example, in the 2010 Irish Football Association versus Football Association of Ireland at paragraph 39, I quote that they said the FIFA Emergency Committee was which decided that a player who acquires a new nationality without having a clear connection is not entitled to play. And in the present case here, she also took away the opportunity for a local athlete to participate in those games. And this concludes my submissions, Madam Arbitrator.
Thank you.
If I may be of further assistance, this concludes my submissions.
Thank you very much for the submission. Thank you, Remy.
Thank you, Mr. President.
There's a rebuttal, is it, now?
Yes, Mr. President.
All right, carry on.
May it please member of the tribunal, I once again reappearing for the rebuttal. In our rebuttal, we will submit 3 reasons why the respondent argument must not stand before this honorable tribunal. First, the GDC's impartiality is still in question. A tribunal tainted by even a hint of bias cannot be trusted to deliver justice, and justice must not only be done but be seen to be done. This maxim, which embodied in the CAS case of Sun Yang, which is more persuasive to this tribunal today. The main point today is not about whether there is actual bias influencing decision or not, but about whether GDC is complying to this very first maxim of fairness. First mistake made by the respondent. They apply the CAS code. However, CAS code is not applicable because the internal tribunal hearing are strictly bounded by their own rule. We would like to highlight that the governing law for this arbitration is Malaysian law, and under Malaysian law, the arbitrator has duty to full disclosure rather than just mere public disclosure. Second, the GDC has failed to abide by its own rule. There are 2 subpoints under this rebuttal point. First, about the rule of relocation. Respondent rely on clarification 22. This suggests that the riot might happen again. We render that this is speculative. We need objective assessment of practicability and not hypothetical. Without any concrete evidence, this is unreasonable and premature. They claim that it was for convenience to move to South Nagaland, but what constitutes convenience? They did not explain it in the submission. Also, we're moving on to the next point, where we noted that there is no legal authority that support Mr. Brandon's submission today in the issue of relocation. Secondly, under Rule 3.1, the GDC failed to recognize that Ms. Zhang was eligible to compete. It was first, this rule must be interpreted according to the Russian Weightlifting Federation case, a CAS case, where it must be interpreted according to its word. They admit that GDC are unaware of Ms. Zhang's citizenship status. The fault is on them because they before that have a duty to confirm the identity of Ms. Zhang before letting her to compete. We can see the relevance of applying the case of Notabum in this case, where it is clear that the issue today is about spotting nationality and not the ordinary issue of citizenship. Of the criteria mentioned by Mr. Brandon in the Mr. Rinaldi case, but it surprisingly favor in our side, as appointed by Mr. President just now. And third, the GDC's decision to
She's
punish
talking
the
nonsense.
athlete is built on shaky ground
Did it make
because
sense?
they rely on
No.
inconclusive
Can
science and a
For 1
sustained
minute, I
blue
got
back
3 points
is
to
not
rebut
even prohibited. We also would like to highlight that in the mood problem, paragraph 30, it shows that Mr. Landon already consulted with the medical team regarding the status of the blue bags prohibition, which shows that he did in fact make an effort to seek clarification from GDC. Thus, how could our client be punished under the strict liability offence when the panel also unsure what constitute an offence? Therefore, members of the tribunal, we respectfully urge the members today to find that the GDC's actions were biased, procedurally defective, and substantively unjust, and that the decision against our clients cannot stand. I conclude my rebuttal. Mashallah.
Thank you very much, Amy.
Before I begin, could I confirm with the members of the panel that you can hear and see me clearly?
Crystal clear.
Thank you, Mr. President. I note that I only have 1 minute, so a brief 3 points in rebuttal. Firstly, we agree with the appellant that Yang is a critical case that determines if there was actually biasness, and we agree that the objective bias test could possibly be fulfilled, but is caveated by the need for concrete evidence, which is not present on the facts. Secondly, the appellant has alleged that the CAS code is inapplicable. This is categorically wrong because we are in the CAS in this appeal, and the CAS can definitely refer to its own code in determining proceedings in and its appeals. And lastly, on the issue of riots, we simply do not know that the riots wouldn't take place more than 3 days, much less we would have known they would take place only in 3 days in the first place. Rather, we have to be concerned that the tribunal has to make a ruling, and therefore they have to shift it to somewhere else where it is safer, where riots could take place and potentially interfere with the proceedings that this tribunal has to rule on. Conclusively, I rest my submissions, and unless I may be of further assistance to the panel.
Thank you very much for your submission.
Thank you, Mr. President and members of the panel. This concludes my submissions.
The arbitration section is now adjourned. Arbitrator, shall we proceed to the feedback section or we shall do it after the deliberation?
Sorry, you're asking me a question, is it? Whether
Yeah.
we give our points first and then we come back for like closing
Yeah.
summary kind of thing. Maybe we do that. We individually score points first, then we come back and then we close.
Get ready to
Yes,
leave the
then,
room. Leave the
Counsels,
breakout
you
room.
may now leave the hearing room while the arbitrator will proceed with the deliberation in the hearing room. The counsels will be re-invited by the organized committee into the hearing room once the marking is over. You may leave this hearing room now. Thank you.
All right, thank you.
Thank you.
Yeah.